we've been told by Rafendi, we now have an ASEAN regional human rights mechanism, which may in the future have potential for accountability for human rights abuse in Indonesia. We've had demonstrations of the enormous importance of regional courts in Europe. The European Court of Human Rights has done extraordinary work, so much so that it's now got tens of thousands of cases backed up, and it has concentrating now on sorting out the basic human rights in the new ex-Soviet satellites. And in South America, Latin America, the regional court there has done extraordinary work in the Velasquez-Rodriguez case and others in condemning acts of violence and enforcing compensation for people who relatives of the death squad victims and relatives of army killings. These two regional courts have, after a while of getting up and running, have been extraordinarily effective. So the recent ASEAN development is hopeful, at least, because Indonesia makes very careful, like Singapore, that it's not a party to any human rights treaty which would allow individuals to make complaints to supervisory bodies like the Human Rights Committee or the Committee on Economic, Social and Cultural Rights or the Committee Against Torture. Indonesian citizens, unlike citizens of other more advanced countries, have no recourse to international human rights mechanisms to assert their complaints against the government. And of course, Indonesia isn't a party, although I think about 112 other countries are, to the statute of the International Criminal Court. And so its prosecutor at the ICC has no jurisdiction to investigate and prosecute crimes committed by the Indonesian army. So the hope is that the ASEAN Regional Charter will be credible and will have sufficient power to review individual complaints and to provide an adequate or effective remedy. I think that's a long way off. The committee has been criticized for its lack of progress, its lack of transparency, but I think probably it is early days. The problem is going to lie in the principles that our friend has to develop. The first principle is respect for the independence, sovereignty, equality, territorial integrity and national identity of all ASEAN member states. So the first thing you've got to do has nothing to do with human rights at all. It's to do with protecting the borders and keeping everyone in West Papua, no independence movement, because that would disrespect the sovereignty and territorial integrity and national identity of Indonesia. Second principle, non-interference in the internal affairs of ASEAN member states. So don't be too critical. That would be regarded as interference. Third principle, respect for the right of every member state to lead its national existence free from external interference, subversion and coercion. So really don't criticize us very much. Let us lead our national existence, even if national existence means setting fire to people's little protesters' genitals and jumping on them and killing them. So that's the 1 to 3 unhappy starters. But then we come fourthly to adherence to the rule of law, good governance, principles of democracy, fundamental freedoms is fifth, and so on. We get to the important things only after the warnings not to be too critical. But we do find in the next section that the duty of the committee is pursuance of a constructive and non-confrontational approach and cooperation on human rights. So no confrontation. That's your that's the direction that you have, and there has been concern that the Commission will not be independent of ASEAN, that it's not funded properly by ASEAN, and so forth. So these are worries. They're there. It's a very cautious, nervous beginning, but at least it is a beginning. And I think the one thing that we can truly take heart from is that these really are very early days in the delivery of international justice. Just think, it might have been 1649 when the first law against impunity was passed by the Parliament of this country, but it took until Nuremberg in 1945-46 before that was made a reality. There were attempts to put the Germans on trial in 1919 for invading Belgium. They were rejected by the Americans. In 1945 there was a massive dispute between America and Britain. America wanted Truman and Jackson, his legal advisor, Supreme Court judge, felt that the Nazi leaders should be put on trial, should have due process as fair as it could be, as the horrors of the time would permit. It was Churchill and the British who were totally opposed to any kind of Nuremberg trial. They wanted the top 72 Nazi leaders, they drew up a list, they wanted them shot 6 hours after their arrest. They'd have 6 hours to say their prayers and then they'd be shot because they didn't want a trial to give Hitler any sort of soapbox. So it was a complete deadlock between the two allies, and it was the third ally who decided it. That was Joe Stalin, who loved show trials so long as everyone got shot in the end. And that is how we got Nuremberg. And then, of course, international justice after the great triptych post-Nuremberg of the Universal Declaration, the Geneva Conventions, and the Genocide Convention, went into the deep freeze during the Cold War. For 50 years nothing happened. Then someone got the bright idea, because as a kind of fig leaf to protect, to make up for the fact that no one was doing anything about the Balkans, and hundreds of thousands of people were being killed by Milosevic and co, that they should set up a court, a war crimes court, and it took some years before the court in The Hague took any kind of effect. So it's early days. So we now have we now have that film. What was Polanski's film called? The Ghost, which really did envisage Tony Blair having to stay in America to write his memoirs because he was being investigated by the International Criminal Court. So impunity, we can at least conceive of the end of impunity. We do have a long way to go. Indonesia, unfortunately, has to go a long way further than most other countries, but at least the ASEAN Regional Court is established.